everybody. I'm very pleased to introduce Jonathan Kimmett, who currently serves as the Chief Information Security Officer for the University of Tulsa. He's been at the university for 20 years. His primary responsibility is the development and execution of the university's IT security and data privacy compliance initiatives. And he has been in information services and security operations at University of Tulsa all of that time. All aspects of information technology at the university. He is president of the ISSA Oklahoma chapter and an InfraGard board member. Jonathan sees the goal of privacy and cybersecurity to protect people and actively works with industries, professionals, and leaders to grow and develop their security and privacy postures for their organization. I'm very excited about introducing Jonathan and his topic, and the interesting background of why sometimes people think it's a kind of a checkbox thing and that privacy isn't key to what happens. But I think his talk will give you a little bit of the history of why it is so important. With that, over to you, Jonathan.
Oh, thank you so much. I very much appreciate it. I didn't know you were going to read my my bio, or I was giving you a little small one. It would have been easier to get through, but I do appreciate that. Well, thank you, everyone. Thank you for having me here. I love presenting at this conference. I don't know if I've done all of them, but I've done a lot of them. And I always have a good time. It's always a great group of people, great questions, great topics. So I'm Jonathan. I am the CISO here at the university, but more importantly, I've been in cybersecurity and privacy for many years now. And I've kind of got a wide range of a background, everything from law enforcement many years ago to help desk, to computer security response team, to CISO, to privacy, to GDPR, things like that. And I really feel like, my past experiences have really, they've built, every piece of it's kind of built onto the next to get where I'm at now. And so today, one of the things we're going to talk about is GDPR's on the brain. It's privacy, and specifically the history of privacy. And I'll tell you why. When I was studying for my CIPPE, my Certified Information Privacy Professional from the Europe laws for GDPR back several years ago, I took it and I was not very strong on the history. Well, I didn't have European history like that. There was a lot of pieces that I didn't know. And so I took the test, and that was the piece that I didn't pass on. I got all the privacy stuff, I got the law stuff, but I didn't get that history, and that's 30% of the grade. So I sat down and I really dove into the history and learning about privacy and what it meant and why it was such an important aspect of EU laws. And I found it fascinating. And because of that is why I'm here now. We're going to talk about history. But I really dove in not just to the history of the EU side, but the history of privacy. Thinking back, we were talking about just a few minutes ago about war games and how that movie kind of started a lot of the common era ideas of cybersecurity in the government and in the world. And it was just a movie. And I think that that's really important to understand, and really important to think about where we come from, to know why we do things, and kind of where we want to go. So I very much appreciate everyone letting me come and babble for a little bit. This is hopefully going to be a lot of fun. I will keep an eye on the chat, so feel free to ask any questions. Some of this stuff I'm not an expert in. I just kind of know it, but I am happy to engage and talk about different things, especially over the presentation about privacy. My job is CISO. My passion, I think, is privacy. I've been doing it a long time. So, it's really important to me to make sure we tie together the pieces of privacy along with cybersecurity, along with all the stuff that we do to protect people. So I hope my shared screen is up. At least on my side it is. So I'm going to assume it is on your side.
Looking good, Jonathan.
All right, perfect. Thank you. So the history of privacy and why do we care? I think that was the other side of the question that I kind of put forward to be this topic is why do we care about it? And all too often, I think people get in this habit that privacy is just about that law, that law that the EU did or that law that California did. And I don't like that mindset. I really want to have more of the background and why privacy is important. Everybody wants privacy. People may not know it, but when you start asking the right questions, you can very quickly see just exactly what people want from their privacy. So this statement: no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor or reputation. Everyone has the right to the protection of the law against such interference or attacks. This is right out of the United Nations Declaration of Human Rights, December 10th of 1948. We're going to get into the Declaration of Human Rights and why it's important and kind of what led up to it and why it's really, in the modern term of privacy that we talk about, this statement is really important. But I like starting this off. I like starting with this statement here because I think it really kind of encompasses all the things we need to think about from a privacy perspective. People ask me all the time, what is privacy? And I always respond, privacy is a choice. It's not binary. People say, well, I've already lost all my privacy, and so I'm not going to worry about it anymore. I don't agree with that. I think it's a choice. It's a choice of whether I want to share my data or share myself or share something that's important to me with someone else. And how I share that and to whom I share is the crux to what privacy, I believe, is what the privacy is all about. My choice to be able to share that or not. So a little bit about myself. I've been in IT and IT security a long time. I've got a whole host of certifications in privacy. I'll tell you, I kind of started in the privacy route by accident. I got into PCI first, paper card industry, which is industry regulation for credit cards. I dove into that because no one else was doing it here at the university. And then all of a sudden they says, well, hey, you got us compliant on that. Why don't you get us compliant on Gramm-Leach-Bliley as well? While I was studying and learning about Gramm-Leach-Bliley, GDPR was just becoming voted on and popular in the news, and everyone was talking about it. So I kind of looked at that and go, well, maybe that's something I need to think about for the university. And so I kind of dove into GDPR, and that really exploded into my path into privacy. Being a small institution here, the University of Tulsa in Northeast Oklahoma, I was one of the few people in Oklahoma at the time. I think there's a lot more of us now, but I was one of the few people that had gotten the CIPP at all. And maybe only 2 or 3 had gotten CIPPE in the state when I got it. There wasn't very many people that were worried about European privacy laws at the time. So I did a lot of speaking on the new privacy mindset, the new privacy laws, and what we need to think about from an IT perspective. So as you can see, I've got a lot of stuff on there. A variety of organizations. I got, ISACA, I've got IAPP. Plus, I've got a lot of the network CISO certifications. I've got 3 or 4 more that I'm working on that I hope to have by the end of the year. COVID kind of took a lot out of my my scheduling for really devoting some time to that. Along with those books, I've been writing those books for a while. I'm hoping to have those out soon. Just got to get the time down to get them finished and get them published. So fingers crossed this next year that I'm going to find some success in that. All right. When we talk about privacy, I really think it's important to kind of go back to when we talk about the history of privacy, we definitely go back, but I want to go back even just further than the view of or the history of privacy. I really want to go back and say, okay, what have we done as a society, as a community, as people, and what parts of privacy are important to us? Well, so I've got a list of here some things that I think is really kind of important to think about from a personal point of view. So back in 1900 BC, the Egyptians used a form of encryption for writing messages. They would do picture swapping. So they would, if you didn't know what the picture was, you wouldn't know what the word was. So it was a form of encryption. And that's really important because back, even in Egyptian, it was important for them to have privacy or confidentiality in the things that they were writing. A lot of people don't know that. When we talk about encryption, if you talk about the history of encryption, I don't even think they go back that far. Usually the Caesar Cipher, which I believe I spelled that wrong. I apologize for that. But I believe that when we're talking about the Caesar Cipher, that's kind of one of the first ones that people talk about in true encryption. But the Egyptians had it, and they used it. So people were already thinking about the confidentiality of the written word, of the things that they were putting out there and why it was important to them, whether it be military secrets or they were just writing a letter to someone. They wanted to make sure that that was private. The Romans, they used locks and keys. A lot of time when we're talking about locks, what are we talking about? We're protecting something, protecting content, protecting ourselves, locks on doors, protecting treasure. So these are things that when we talk about privacy, I know locks and keys don't really tie into it, but it does. If you have something you don't want someone to get access to, what do? You lock it up. And the Romans were some of the first to actually use locks and keys. Julius Caesar, in terms of the Caesar cipher, where they offset the alphabet. If you've ever done any sort of encryption, you know kind of what this is. But basically, if you've got, if it's A, B, C, D, E, F, you got your alphabet, and you shift your letters over 5. And then line them up, A is a E and B is an F and so on. And you write your words in this cipher. Now, it's easy to crack, and nowadays it's one of the first things that people try. But back then, it was a process in which they could encrypt messages to one another because they didn't want that public knowledge for whatever reason, whether it be, again, military or personal. It didn't matter. They were using processes, and specifically a cipher, to prevent people from reading messages. And we still do that today. We encrypt data so that people who are not authorized to access it can't access it. Greek houses. Now, this is kind of fascinating to me. My wife and I, we watch a lot Discovery type stuff, History Channel type stuff, whatever we can get a hold of. And I love watching about old buildings and old cities and how they built them. I just find that really fascinating. But one of the interesting things about Greek houses is they were kind of one of the first, when we talk about, historical housing, a lot of times we kind of think about, huts and large rooms where lots of people sharing beds and sharing fires and stuff. But the Greeks, they made a big deal about making sure that when they built their houses, that light could get in the windows and lighten up their rooms. But you really couldn't see in them. I mean, there was a lot of stuff that was, quote, hidden from view. So when you go back and if you do search for privacy Greek houses, you'll find all kinds of documentation on there. But you could see where they built the house, and they have these geometry lines where showing where the light would come in and light up the house. But visually, you couldn't see anything. So I find that fascinating. Even back then, they were thinking about how do we make sure that people can't see in these windows and see what's happening inside the house. 800 AD, all metal locks are used. That was kind of the genesis of the locks and keys from before, but they have all metal locks. That was, I believe, I can't remember now exactly. There's a name that goes along with it, but that was kind of one of the first times that, you have a kind of an all-in-one self-contained unit of a lock and a key, all metal that you put on a door. So, again, these things are really just stuff that what did and historically, how did people protect their stuff? protect their data, protect their information, protect themselves. And these are just kinds of these things that we talk about. Now, in 1215, the Fourth Council of, I'm not going to say this right. If people know how to say it, please don't, throw tomatoes at me, but it's Lateran. Back from the point of view of the Catholic Church, the religion, one of the things that came out of this was specifically confession. And the idea of privately confessing to a priest, and also privately worshiping, this became a very important thing, that it became your worship and your confession becomes a self-internal part of this. It's not just you do it in public, you do it out there. You're really focusing on an internal aspect of your religion. But it's really kind of important because, religion, as it has come down to the ages, has kept a lot of these pieces and a lot of the mindsets from, having that solitary unit. I remember reading a story once where some monks were, if you guys remember, I know this is going to be kind of funny, but Star Wars, one of the last movies that came out, with the new Luke Skywalker, with the older Luke Skywalker, he was on an island with the huts, with the rocks pounded up or stacked up in a big hut. That was actually if I remember the story right, monks lived there and they worshipped there. They studied there. And the anecdotal story was that there was a monk who had passed away in one of these huts, and no one knew it for several days because they were so solitary that it was not uncommon for people to be in those huts for days on end, praying or studying or doing. So it was a very private ordeal for them to be in those huts alone while they're focusing on things. So again, if it is a true story and the monk died, I don't want to minimize that by saying it's Star Wars, but it is something that most people now have seen those. They never knew what they existed before, but now you kind of know what the history is of them. 1350, the Black Death. If you know anything about history, you kind of know what the Black Death was and about how when we're talking about the Black Death, it was transmitted by the close contact of people. So those people who had individual rooms were much less susceptible to getting sick, whereas the people who all lived in one room, and they would have 8 or 10 people in a single large bed sleeping together. Your kids, your servants, sometimes your family. And that's what allowed that, the disease to really spread quickly, is there was no division in people. Kind of thinking about COVID, we all kind of went to our own homes for about a year and a half and stayed there. So same kind of thing, it's, there's a lot of benefits out there, of this solitary mindset of, okay, we're going to protect ourselves and things. So, right or wrong, I'm just kind of saying what the history is of this. In 1778 was the first tumbler lock, the basic lock that we have today with pins dropping up and down. That came out in 1778. I just put that on there because, I do a lot of physical security and I thought it was fun, and kind of looking at your Romans all the way down to the current design of the tumbler locks, kind of have this full rotation on there. All right, so now let's get into the crux of this, talking about the real history of privacy. So the things that we just talked about is things that we normally don't think about as privacy, but it is. And it's stuff that we need to think about, is that, hey, we were thinking about this stuff, thousands of years ago, and it was important for us then. It's important for us now. So when we talk about privacy, this is a lot of the stuff that people may have heard of, maybe not. So let's talk about the Post Office Act of 1710, Section 40. XL is 40. This was the Post Office Act when we were colonies. So it was a British Post Office Act for the colonies. And specifically, this talks about the postmaster, or those who manage the mail, would not read the mail. Now, I think that we kind of take that for granted nowadays, that when you put something in the mail, that it's a secure thing. In fact, when we're dealing with PCI, if part of your PCI process is to receive credit cards through the mail, at least historically it was, the moment it went into the mail system, i.e. the mailbox, to the moment that you picked that envelope up from the mailbox, that was a, quote, PCI compliant process. Well, where did that start from? And the beginning of Section 40 from the Post Office Act of 1710 says, willfully opening, embezzling, detaining, delaying of letters or packets to the great discouragement of trade, commerce, correspondence, for the prevention thereof, blah, blah, blah. And basically what it says is this law says you will not willfully open, you will not embezzle, you will not detain these letters on the grounds that you're going to get fined and or other things may happen to you as the postmaster, as someone who's in charge of delivering this mail. And that was in 1710. Now, we're going to talk about different aspects of the post office because I think it's important because if you remember back in the time, postcards were much more prominent than letters inside of envelopes. So you write on the back of the postcard and you send it on, and most people, they don't really care if someone reads on the back of a postcard because you're just like, well, yeah. But it really was important because you want to be able to trust that process, that when you put a post in the mail, that it's going to be secure and that they're going to get it on the other side and no one's going to mess with it. And I think that we take that for granted now, but they had to write it in 1710 because there was abuses. People would read it and they would gossip. Gossip is a huge thing throughout time. And they would read someone's letters and they would gossip about it internally and that would spread. And they didn't want that. They wanted to make sure that when you sent something through post, that it was going to be private and it was going to be secure. There has to be that trust there to use that product or use that service. Now, the Revolutionary War. That's kind of the next in line for my trip through history of privacy is the Revolutionary War. Specifically, the writing of the Constitution and the Bill of Rights. There's a lot of contention that the word privacy is not in the Constitution. A lot of people talk about that. We don't have a Bill of Rights that specifically says you are entitled to privacy, like it is in GDPR and the data protection, or actually the United Nations Declaration of Human Rights has it in there, plus a few other ones. But we don't have that. But we do have the Third Amendment, the Fourth Amendment, and the Fifth Amendment. So when we talk about the Third Amendment, what does that do? That it prohibits the practice of quartering soldiers in your homes. The government can't say you're going to house these soldiers. They can't come into your private residence. The Fourth Amendment, that people have a right to be secure in their persons, their houses, their papers against unreasonable search and seizure. That the government can't come in and just take your stuff and read through it, and publicize it, and do whatever, that they have to go through a process for it. And of course, the Fifth Amendment, that a person can't be a witness against himself. They can't, or herself, in criminal cases. So these three amendments were kind of that response to that of, I believe, that response to what the founding fathers saw as things they didn't want to happen because it was happening under British rule. So they specifically wrote it in there saying, we don't want this to happen anymore. The third, the fourth, and the fifth, along with all the other ones as well. But those are the three that they help us when we talk about privacy and protecting what's yours, your data, your correspondence, your home. These are the things that help protect against that. And I think it's really important to realize that, we read these and sometimes we don't think about the connection to that of other things. And to me, these really do lay out that privacy protection that the Bill of Rights gives us, or the Constitution gives us. The next one, John Adams' Note of 1770. I really like this one. I did this one I did this a similar presentation to this a couple of years ago. And when I read this, you'll understand why it was interesting at the time. I probably should have pulled it out because it was highly contentious, but I didn't. I only read it. But John Adams, he was not president at the time, but he wrote in a handwritten note. He says, "I am under no moral or other obligation to publish to the world how much my expenses or my incomes amount to yearly." So if you follow politics at all, there's always this issue of tax returns, no matter what, which president it is, there's always an issue or some other paperwork they won't release. But it was really interesting that John Adams wrote this, and it kind of fell out of, historical sake for a while, and then the history people, the privacy people kind of brought it back out. But it is a true statement that, even back then they were thinking about it's nobody's business what I make and what I do in terms of how much money I make. So again, it's just a small piece, but I think it's important. I think it's important for people to realize kind of where those things come from and why certain pieces are important nowadays. 1782, the Continental Congress, same thing, the Postal Ordinance. It specifically, what it did was it outlawed postal officials from opening mail. Unless there were some exceptions in there, if it was undeliverable, if there was a problem or whatever. But it was otherwise illegal for them just to sit down and start reading your letters you were sending through the post office. And in fact, one of the punishments, I found this really interesting when I was doing research back a long time ago. It says in 1792, Congress, in Section 17 of the Act, included death as a possible punishment for robbing a mail delivery person or for stealing mail from the post office. Now, they redacted that, or they reduced it to 5 years in prison later on in the 1800s. But in 1792, for you opening mail or stealing mail from the post office or robbing a mail delivery person, you could get the death penalty. They were serious about it. They were U.S. Marines were deployed. Yep, absolutely. It was postal mail is really important to the world, really. And it was so important to them that Congress says, you know what? If you rob the mail service, if you steal mail, you could get the death penalty. Now, I don't know how many people got it. I've never done that specific research. But when I read that the first time, I was like, oh, my. But then I flipped it over. It's like, you know what? That really, it is important to realize I think it's important to realize just how important the post office was and making sure that content sent through the post was protected. So I find that fascinating. The next one, right to privacy. Now, we talk about right to privacy, but that term or that quote there, right to privacy, didn't exist really, at least in terms of the historical record, until 1890 from the Harvard Law Review. And what it was an article written December 15th of 1890. I remember that. Well, doesn't matter why I remember. I do remember that. I don't remember it actually happening. I wasn't alive then, but the date I remember in my head. But what it said, I'm going to read what it says. I've got it in my notes here. It says, the intensity and complexity of life attendant upon advancing civilization have rendered necessary some retreat from the world. And man, under the refining influence of culture, has become more sensitive to publicity, so that solitude and privacy have become more essential to the individual. But modern enterprise and invention have, through invasions upon their privacy, subjected them to mental pain and distress, far more than could be inflicted by mere bodily injury. Now, I will say, let me ask you, how many times have you been just so bombarded with stuff? People asking questions, wanting something from you, or that it just got so stressful you had to pull away. You had to get time away, you had to pull away some, get off Facebook, get off Twitter, just for your own mental health. that's kind of what they were saying, that every person has the right to privacy. They have the ability to step away from, quote, the world or the processes in the world, from bugging you, I guess is a good way of saying it, at least in this part of the article. But that right to privacy is very important, because I think it's true. I think for some people, being out in the world, with their information, actors and actresses say it all the time, that it's really difficult to be, famous, because they don't get any privacy. They can't go anywhere without someone stopping them, wanting a picture or thinking they know them. I mean, and that's we have to think about it like that. That it can be a drain on someone, and that right to privacy is really important. Telegraph. Now, this is something that I'm very much interested in, the technology side of stuff. So I've researched it. I'm also a ham radio operator. So when we talk about early communication, long distance communications, I find this stuff fascinating. But as it relates to the telegraph, has anybody ever really thought about the privacy side of the telegraph? I mean, at the turn of the century, telegraph was the primary long distance communication. I mean, that's it. So if you were going to communicate with someone, the telegraph was the only way to do it. And so when you were sending messages, sometimes you didn't want to send messages that everyone would know. So you had to encode them. So back to what we were doing in the Caesar Cipher and the Egyptian encryption, that you want to encrypt that data going through. Now, sending telegraph was really, really difficult. You got to have the infrastructure, and you had to go to someone and they would send it and so on. When wireless came out, when wireless communications came out, it was fascinating to me. The telegraph was marketed as the private alternative, because someone could intercept that Morse code as it was going over the air. It wasn't Morse code at the time, but as those signals going over the air, whereas on telegraph it was a little bit harder to intercept that. You can, but they were claiming as a marketing action or a marketing process as more private than that of the wireless communication. Now, we still have the same argument, honestly. In fact, I'm in the middle of getting my PI license, and we were talking about wiretap laws, specifically voice over IP on a wired network versus data that's sent over a wireless network. And the courts have stated that if it's over a wireless network and someone picks it out of the air and can decode it, that's not wiretapping. Now, I don't have the laws in front of me. I don't have the court case in front of me, but that's something that I've been researching here lately. Because even though people may not know the technology behind it, the fact that it's wireless means it is kind of by default public, because you got to send it out there. So they could grab it. They could, maybe not. They may not be able to decrypt it, but they could grab it. If it's clear text, they can read it. And I've got a whole other story about a pineapple and what was done at a conference that, many of you may have heard in the past, but I'll tell that story some other time, about things that were picked up over the air, and you could see what people were viewing. And, it's kind of a funny story. But, when we're talking about telegraph and the privacy, people go, oh, yeah, I never thought about that you do want to make sure you protect those communications. And it's the exact same process that we do on an IP network, an Ethernet network. How do you protect that data? If you've got a tap in the network and you can grab that data, is that wiretapping? Maybe. I'm not a lawyer. I'm not going to say it is or it isn't, because it all depends. But it is something we have to think about in our organizations, in the cyber side and the privacy side. What is allowed and what's not. And this is the same stuff they were doing at the turn of the century, the 19th and 20th century. So keep that in mind, something to think about. All right, the 1948 Declaration of Human Rights. Now, let me ask you, why was the 1948 Declaration of Human Rights so important? And usually when I'm in a room full of people, I will ask this question, and I'll kind of guide the questions around to get the answer. But the answer is that the Declaration of Human Rights by the United Nations is a direct response to World War II. Specifically, the collection and murder of the Jewish people. Now, everyone's like, well, why does that matter? I mean, of course, it's a terrible thing that happened, but they go, why does that matter to the privacy side? Well, it's like, well, how do you think the Nazis found all those Jewish families? They asked people. They had it on the census data. They had it on paperwork. They collected them. And, millions and millions of people were murdered because of what they believed in, what they thought, how they acted, how they looked. So when the United Nations came out and says, you know what, we don't want this to ever happen again. So the 1948 Declaration of Human Rights basically says, hey, everyone has a right to privacy. They have a right to protect themselves. They have a right to protect what they believe in and their person and their belongings and their house and all that, because they don't ever want that thing to happen again. So that was the catalyst to what has been the modern version of privacy, was the UN Declaration of Human Rights. We're going to get a little bit more to that in a few minutes. But that one has a really good catalyst. I always ask people, has there ever been a death because of a data breach? And one of the examples I use is the Holocaust, because the data that they got on those Jewish families was collected years before, and then someone went and used that data for the purposes of finding those families, collecting them, and then murdering them. And that's something we don't ever want to happen again. I'll tell you, that right there, that piece, when I was really getting into privacy, that hit home for me. It's like, that is the reason why I take privacy so important, because I don't want that to happen again. I don't want anybody to get hurt, lose a right, anything, because I didn't do my job as a CISO, do my job to protect their data. So I'm not going to get on that soapbox because it's very easy for me to get on. I want to get on to the next segments of this. Well, the Declaration of Human Rights immediately went into the Data Protection Directive. Well, not immediately. It was, 50 years later. Went into the Data Protection Directive. Now, this was a directive. This was not a requirement, a regulation in the EU, but it was a recommendation for all member states to really get into protecting the data. And specifically, it's because of the growth of the computers and the internet. And we'll talk about that in a little bit. And then from there, GDPR, CCPA, and CPRA. Now, these are all current laws. GDPR, CCPA, CPRA. GDPR, of course, is in the EU. The CCPA and the CPRA are California data protection laws here in the United States. They're some of the very first privacy laws that we have, and we're going to talk about a little bit more in a little bit later. But these were kind of the beginnings. This is what started it all for us. Why I'm here, actually, is that GDPR started me down the route. Therefore, you push all the dominoes to where I'm sitting here in front of you guys right now. I may be boring you, but I am here, and I appreciate everyone listening to me, mumble about this stuff. All right, so let's talk about some of the things here in the U.S. When we talk about privacy laws, a lot of people say, hey, we need a privacy law. We've actually got a lot of them. Secretarial, of course. We have a lot of separate laws that kind of overlap on a lot of things. We don't have one law like GDPR that covers everything, but we do have a lot that we need to think about and, research. So the FTC, if you know anything about the FTC, it's kind of an independent agency of the United States government. But their job is to protect people. So they were put in for non-criminal offenses, antitrust laws, big corporations. Effectively, what they were doing, or they do, is they protect the individual citizens from abuses from large organizations. Now, I don't want to say large organizations because it may be an individual, but it's still, or like a sole proprietor or whatever. But their job is to protect, and they've kind of taken on this role over the last however many years that is, 100 and some odd years, of protecting people. And we do not have a privacy department now, a Department of Privacy. We might get one in the future, but right now the FTC kind of takes that role. If you read on their website, they actually are privacy enforcers for a lot of different things, but it comes down to if an organization is going to violate consumers' privacy, they're going to come back in. They're going to say, okay, stop that. You're doing bad things. You're not protecting the customer. We're going to stop that. And it's going to be based on other laws and various other things. So it is important to think about the FTC kind of in the beginning, 1914, and how they've grown in terms of what they do and their charges for protecting the consumer. Specifically, I'm going to say, because I got a note here, since 1998, they are going after privacy violations. And it's around this unfair and deceptive acts or practices affecting commerce. So it really is, they're taking what they were charged with and they're using that to enforce privacy regulations and privacy protections to the consumers. So they've done some really good things. I've kind of kept up. If you go to their website, they've got a section just for privacy, and it's really interesting to read through it. They also do a lot of DPIAs, data protection, data privacy impact assessments, where organizations, they do an impact assessment of their processes and procedures of how it's going to affect them. So I go there a lot to get DPIAs of other organizations and to get ideas on if I'm doing a PIA for something that I'm doing, I can see the format and such. So their FTC website, go take a look. It's good information. The 1934 Communications Act. This is interesting because a lot of people, they kind of forget about it. What it talks about is carriers, so the telecommunication carriers, subject to the obligation to guard the confidentiality of customer proprietary network information, and make sure it's not disclosed to third parties. Now, there's a couple of these that we're going to talk about that has a direct impact on what we're doing now to what some of the things that they were dealing with then. And I think you need to kind of put that together in your head of, as a telecommunication carrier, it's your responsibility to protect those communications and customer privacy on those. So just a little mental note, keep that in mind. Now, the Fair Credit Reporting Act, kind of the same thing. Now, this is actually one that is a big thing in the PI class that we're having to go through is the Credit Reporting Act. And it talks about if you are a consumer reporting agency, you have lots of regulations. Like if I was going to go to LexisNexis or Clear or any of those, and I'm going to if I'm going to go to the credit bureaus and pull your credit report, there's all these things that I need to do to make sure I'm doing it for the right reasons. I've got to, get consent. I've got to have a court order. I've got all these different things because you can't just go and look at it. You can't just go and go, hey, this person's got really bad credit and go tell the world about it because you're not protecting the consumer at that point. In fact, one of the aspects that as a private investigator, someone comes to me and says, hey, I want you to do this investigation and give me the credit report from this individual. And if I believe they're not going to use it in a good way, or if they're doing it they're going to misuse it, I'm not allowed to give them that information. So just keep that in mind. There's a lot out there what you can and can't do. Privacy Act of 1974. This is basically the collection, the maintenance, and the use of PII by the government. How they're going to use it, where they're going to store it, all these different things, and we're talking a little bit about laws in a minute, but how does the government deal with your private information, such as Social Security number? There's some rules behind what you can and can't do with a Social Security number from the government perspective. So the Privacy Act kind of covers some of that stuff. So it's an important aspect of history of privacy here in the U.S. Now, the next two, Cable Communications Policy Act and the Video Privacy Protection Act, these kind of go hand in hand. Basically, I'm not a lawyer, so I'm just going to tell you the general summary of it. What you get in a video store or what you read on or what you purchase on cable, you can't share that with anybody. In terms of the cable provider or the video store provider, I'm not going to say, well, such and such rented these movies. Now, we all know why that's an important thing. Maybe not specifically this, but, people will go, oh, yeah, no, that's not something that you should not be releasing the videos that I used to rent at the VHS store, or, buying on cable or any of that. That's all protected information. And there's some funny things that happen, or I think they're kind of funny, that led to that, but it's just a reality. You can't give out that information. It is private information. Now, Copa, Children's Online Privacy Protection Act. If you've ever dealt with K through 12 or anything that deals with children, you have to kind of think about Copa and how your processes are going to affect that. For children under the age of 13, privacy policies for websites, parental consent for collection, use, or disclosure of the PII of those children is really, really important. And if you're doing anything that deals with children's information, you better get up to speed on Copa and what you can and can't do. Now, when we get to the next ones, the HIPAA and Gramm-Leach-Bliley, everyone kind of knows these. I won't go into a lot of detail about them. But, HIPAA, of course, is the Health Insurance Portability and Accountability Act. And it was really dealing with health privacy, how health data, the security and privacy rules of HIPAA, and how you're going to maintain that data and store that data and transmit that data to covered entities back and forth and those sorts of things. And then Gramm-Leach-Bliley, same kind of thing, but from the financial institution's perspective, making sure that an agent of an organization that has this data from the financial institution ain't going to share that out inappropriately. So GLBA is something that's close to my heart because that's what I started in outside of PCI, and that's what led me into privacy for GDPR. So I deal a lot with GLBA from here at the university's perspective. Okay, so that was a lot of U.S. privacy history. Now we're going to go to a little bit of the EU. I'm not going to go into a lot more detail because I have a few other things I want to cover. But the Declaration of Human Rights, I think, is really important. We kind of touched on it. But the next one, the 1950 European Convention of Human Rights. So in 1950, the European states adopted or created this European Convention on Human Rights to respect the private and family life, the correspondence, all that stuff that the Declaration of Human Rights was otherwise saying in its document. They just formalized it and asked all of their states to agree to it. And in Article 8 of the European Convention on Human Rights says it provides a right to respect for one's private and family life, his home, his correspondence, subject to certain restrictions that are in accordance with the law and necessary in a democratic society. There are exceptions for life safety, for law enforcement, things like that. But as a general rule, Article 8 covers the same kind of thing the Declaration of Human Rights does. So those things are really important. It was signed by all member states, and the convention created and established the European Court of Human Rights, a whole court specifically to protect human rights. So if a person feels their rights have been violated, they can go to this court and they can make their case and go through the process on determining whether or not it was or not. The 1980 Convention for the Protection of Individual Rights. Sorry, where am I? I think I've missed this section. So we were talking about the guidelines of privacy and the flows of personal data from 1980 OECD. This was a direct response to the fact that data was being sent back and forth over state lines or country lines. And that became a problem because as technology was getting better and people were sending data back and forth between servers or computers and computer networks, that became a real issue on whether or not those states were going to protect that data. So when we're talking about the flows of personal data, that was what that was about, was, okay, technology is getting better. We're sending data back and forth. Oh, we better protect it. So let's put some things in place to protect it. So that was what that was about. The 1981 Convention of Protection of Individual Rights in regards to the processing of personal data, Convention 108. I'm sorry, there's a lot of words here, and I'm getting low on time, so I want to make sure you get all the pieces in. As data was flowing, as we were collecting, we as a society were collecting data, and we were processing that data, and processing in regards to this could be viewing it, seeing it, storing it, automated processing, doing algorithms on it, doing AI on it, any of that stuff. Anything that deals with that data by an individual, including storing it, kind of fell under that processing of personal data. The idea was we are expanding out those protections to cover all the different aspects of that data as it relates to processing of that personal data. That led to the 1995 Data Protection Directive, which we talked about earlier, was the beginning of the GDPR mentality. It was, okay, so we've got this convention for the protection of individuals with regard to the processing of personal data. Great. What does that mean? Well, they turned it into a directive, a data protection directive, and they had all these things that they lined out of what you could do with the data, how do you store it, how you respond to breaches, how you do all these different things. And that kind of got formalized into the Data Protection Directive, which was passed out to all the member states of the EU. Now, it was not a regulation. It wasn't law yet. That's what GDPR turned it into, was law. But the Data Protection Directive was all these guidelines, and everyone was doing it a little differently. You know, Germany versus France versus this versus that. They all did it a little bit differently, and, you know, there was problems. And in 2010, the data protection reform started. Where they said, okay, we really need to do things differently because there's too many networks, too many computers, too many things happening where it's getting out of hand. So they wanted to start bringing it all back together, where they say, okay, we need to do data protection one way, at least as it covers all states, and we need to do it in a standard way. So in 2012, the proposals for the GDPR were begun, where people started taking pieces out of the UN Declaration of Human Rights, the guidelines for the flows of personal data, the Convention of the Protection of Individual Rights, the Data Protection Directive, and they started merging it all into one regulation, the GDPR. And in 2016, the final version not final version, but the final version that was voted on came out. They voted on it, and it was approved, and it went into enforcement in 2018. So that's kind of the history of the EU data protection regulations, a very surface layer of it. But GDPR specifically is a culmination of everything that's happened, you know, from antiquity on down, but specifically from 1948, and how it's built into the individual pieces, talking about the flows of data, personal data over state lines, you know, country lines, all the way to how to protect the data, how to store data, how to do breach notifications, all these things. That all builds into GDPR. It wasn't just created overnight. It was created over 50, 60, 70 years of effort to get to this point. Now, why this is important is because CCPA, CPRA, the Maine privacy law, New York privacy law, the Virginia privacy law, all of the things that you see, we'll see in the next slide, all comes from generally the GDPR. At least it was influenced by the GDPR. Now, the very next slide, I think this is a really, so we've got the data, the rights of the data subjects. So we're talking about data privacy rights. I left this in here from another presentation. Transparency of how you're using the data, access to the data. They want to know if you have data on them, rectification of data, right to erasure, right to portability, right to object, along with a bunch of other ones. But these are the common ones, and these are things that we've talked about a little bit. On whether or not people have the data about you. You know, these are the things that we want covered. But this is really what I wanted to get into. So this was, I actually grabbed this picture back in January of all the privacy laws here in the United States. And what's interesting is, and you can see, you know, of course, California has already got signed laws, Nevada has signed laws, Maine has signed laws, but look at all the blue and the purple. So these are other states that are introducing legislation, or they're bringing in legislation. They're doing their committees on it. I pulled this yesterday. It's an up-to-date map. So look at the difference. So you have all these different things. Now, Nevada and Maine, it's kind of swapping on. This is just a website, so they do things, you know, differently depending on what it is. But look how many states are introducing privacy legislation. Even just from the beginning of the year, we have 4, 5, 6 more states that have introduced legislation of privacy laws. It honestly is very similar to the GDPR and CCPA and CPRA. A little bit different in terms of the terminology they use and the rights that they're providing, the rights for individual action, things like that. But it's growing, and we are constantly growing, and that's really important because all the stuff that we've talked about today, it's here. It's been here for thousands of years. Now we're formalizing it, we're putting it in the laws, and we're really moving forward with those protection of individual rights. This is another grab that I got from Varonis. This was just an interesting one, and I think one of the things to think about on this is when you read through this, and these are just some of the privacy laws that we have, but right in the middle it says the private right to private action. So what these are is for violations of privacy, these laws in these states are giving their citizens, their consumers, the data subjects, as you will, a right to private action. So they can go get money from an organization that violates their privacy. Some states don't have it. It is very controversial. I expect more and more states to have something like this. If an organization violates someone's privacy, it's going to get to the point where they have options in a court system that they can go get remediation of some kind. So from an organizational point of view, I think you need to think about these things because as the laws are growing and, we're seeing the laws grow, more and more states have them. Many states are going to have a private right of action. So if we don't do good cybersecurity, and we lose that privacy protections for that data, then the individual data subjects have a right to action. Now, from my own personal viewpoint, I like that because, I want people to have their data protected, and if it's not protected, then there needs to be something there that they have a process that they can go in and say, hey, I disagree with your process. I need you to do better, protect my data better. Some of these things I've kind of left in here just for conversational topics. So one question is, are these laws based on where the server is installed or where the people live or where the company is headquartered? The answer is yes. It can be based on all of those. I'm going to stop my sharing now and just come back up on camera. So the answer is it can be all of the above, just depending on where it is. So if the data is so let's say the data is in Ireland, it's in an Office 365 installment in Ireland or a data store in Ireland, it would definitely fall under the Irish laws. But if the organization was housed in the United States, they just use that data center, you're going to fall under U.S. laws. If the data subject was from China, then that data subject is going to fall under China's new privacy laws. So you could be all of them, and it could still affect you in all three of those areas, and they could have an action against that organization because the data resides there, or they're from there, or they're headquartered there. So I'm not a lawyer, so that's going to be something the lawyers are going to have to hash out. But the way I look at it is it could be all three, and it could actually be all three at the same time. So open it up. I've got 1 minute left to 5 o'clock. I'm happy to answer questions. I know I threw a lot of information at you guys. I appreciate you hanging on and listening through that. I know history can be a kind of boring, but I hope you took away some nuggets that can help you in thinking about this stuff a little differently and otherwise protecting your organization, protecting the privacy of your users, of your people, but also protecting the organization itself from violations of these privacy laws.